piece of legislation, and that's what the Bill of Rights was. It had to go through both houses of Congress. You had the House of Representatives deal with it. Usually they send it to committee, and that's what they did here. They designated a committee to review the proposed amendments. Committee approves them, tinkers with them, approves them, sends them to the House of Representatives in the form of a bill. The House votes for it. It gets sent to the Senate. The Senate sends it to committee. They tinker with it some more, approve it, then send it to the full Senate, and the full Senate adopts it, votes for it. In this case, as often happens, the two bills passed by the House and passed by the Senate weren't consistent with each other, and so they have to have what's called a conference committee between the two bodies to work out the differences. They do, and then both the House of Representatives and the Senate vote for it. Same legislative process that we have today. But what happened in this process? The decision was made, okay, the decision was made to set the proposed amendments, set them forth as individually numbered, in individually numbered paragraphs, 12 originally. For some of the amendments, that meant that they took Madison's proposed interlineations and mashed them together. That's why the First Amendment is a grammatical mess. That's why the Second Amendment is not just a grammatical mess, it's almost incomprehensible. And the same is true of several of the other original amendments. And it was because of the legislative process that they had to use. So, adopted, let me see, did I miss something here? Okay, here's one thing I think that you might want to know. And that is, in 1925, in a Supreme Court decision, the Supreme Court extended the First Amendment to the states. And by doing that, it legally extended it to every state-created entity. The University of Kansas, towns, cities, counties, are all creatures created by the states. And so once the First Amendment was applied to the states, it then applied to actions by the Lawrence City Commission or the Kansas legislature. And that's, if you want to get into the details, I can tell you that's a consequence of the 14th Amendment. So, but don't worry about that. Just know that since 1925, the First Amendment has applied to the states, and the Supreme Court used a similar process to apply the rest of the Bill of Rights amendments to the states. Okay, why the grammatical mess? All right, so the 6 protections formally in the First Amendment. Each one of them is there for a reason that I'll go over with you. No official state religion. Freedom of practice of religion. 2 entirely different things. Completely different concepts. Freedom of speech, freedom of the press. Now here, this is the kind of stuff that scholars, academics, think is really fascinating. What does press mean? Remember, back then, other than handwriting, how did we express ourselves in writing? The use of the printing press. And so a lot of people say, well, the word press is referring to technology, how the written word was communicated or written down. Or does it mean the press as today we refer to it, the media? Does it matter? No. Don't be concerned about that. The way I say it is, it's 2 sides of the same coin. It's the drafters of the First Amendment trying to be, let's say, universal. The 2 major ways of expressing ourselves is speaking, speech, and writing. Outside of that, what more do we need to protect? And so that's why, again, don't worry about the application of the First Amendment to specific methods of expression. Just know that it applies to all types of expression. And then, freedom of assembly, the right to assemble peaceably. That has been interpreted to apply to all sorts of situations where people get together, people of like mind, political parties, fraternal organizations, private clubs. So just think of this as guaranteeing to us the right to get together with people that we're in agreement with or opposed to, so we can debate. And then finally, freedom of petition. This is something that I bet you all of us exercise every single day. And that's complaining about City Hall, complaining to City Hall. The guy next door won't cut his grass. It can be as prosaic as that. That's petitioning the government for a redress of grievances. You tell them what's wrong and what they can do to fix your problem. As I mentioned, this is the only part of the First Amendment that was in the Declaration of Independence. So that's kind of an overview of the protections. I'll go into some detail. Okay, now, no established religion. Why do we have that? Just think of Henry VIII. He didn't, married to Catherine of Aragon for 20 plus years. She gave him daughters, but no son. He wanted a male heir. And so he said to Cardinal Wolsey and to Thomas More and to everybody who would listen to him, I need a divorce. The only church at the time was the Catholic Church. This is in the early 1500s. And so, who's the only person who could grant a divorce or an annulment? The Pope. He can't grant an annulment because that means the marriage wasn't consummated. We know that wasn't going to fly very far. The Pope refused to grant him a divorce. He was also having an affair with this nice lady, Anne Boleyn. She's the one he wanted to marry. And he says, okay, I'm just going to create our own church, and I will grant myself a divorce. So he created the Church of England. I'm a member of the Church of England, Episcopalian, Anglican. That's the church I grew up in. But the most important thing from Henry's point of view is the Archbishop of Canterbury, who he designated, who had been a Catholic archbishop, he designated that person to be the head of the Church of England, and that guy granted him a divorce. Oh, everything's hunky-dory. He marries Anne Boleyn. Of course, she loses her head a few years later. He ends up having 6 wives, I think 2 of whom he had killed. But a lot of people in England didn't want to become Protestants, didn't want to become members of the Church of England. They remained Catholic. And so for the next 150 or so years, there was this constant battle between the Protestants and the Catholics in England. And it got to the point in the late 1680s where Parliament, which was largely Protestant, said, we've got to get rid of King James. It was King James II, because he's a Catholic, and we've heard that his wife is pregnant, and oh my gosh, there might be a Catholic heir to the throne. We can't allow that to happen. And so that's when they crossed the North Sea and talked to the person who was at that time the King of Holland. His name was Willem, translated to English William, and his wife was Mary. And Parliament said, why didn't you hop in a boat and come across the North Sea and become our king? Because he was Protestant. And he said, well, okay. And that, 1688, that was the year of the so-called Glorious Revolution. King James absconds to Ireland, and ever since, England has had a Protestant king. In fact, there's a law in England that says that the monarch must be a member of the Church of England. So a Catholic can't be the king of England, a Jew, Muslim, think of any religion other than, or any other sect of Protestantism other than Anglicanism, none of those people can be the English monarchs because of English law. So you have 150 years of a complete mess. And the people who wrote our Constitution and our original Bill of Rights, to them, yeah, that was history, but it's pretty recent history. I mean, think of us talking about the Great Depression. We talk about it all the time. Think about us talking about World War II. That is as far back as the events that the drafters, Madison and the others, who drafted the First Amendment, when they were thinking about, well, what were the problems in England that we don't want to follow? You know, we don't want that to come to us. One was an established religion. So he said, before we get into any kind of trouble with this, we're simply going to say Congress cannot establish a religion, period. So that's why we have it. Then, freedom of belief, freedom of religion, that's the other part of the first clause of the First Amendment. And that, you'd say, well, that seems obvious. But again, historical reasons for that. Many of the colonies had actually had established religions. Pennsylvania, Quaker. Maryland, Catholic. Virginia, Anglican. Massachusetts, Puritan. So these states, colonies becoming states, they had established religions. And there were lots of people who had immigrated to the United States, small groups, Baptists, Jews, and a lot of Catholics as well, who felt they were being persecuted. And so they said, okay, we're not going to allow that to happen. We're going to have freedom of belief. So that's why that part is in the First Amendment. Then freedom of speech. Seems like that one's pretty obvious, but the Brits had occupied Boston in the early 1770s, before the Revolutionary War really started, and they had imposed restrictions on what people could write, and what people could say, and the same was true for the colonial governments in the rest of the colonies. You may remember that the colonies had their own representative government, House of Burgesses in Virginia, elected by the voters in the colonies. And then on top of them was a colonial governor, someone selected by the king to be the governor. In Massachusetts, if you look at Revolutionary War history, you might remember the name Hutchinson. Hutchinson was the colonial governor of Massachusetts, and he caused all sorts of problems. And essentially, what the decision was made, we want people to be able to say what they want to say. Expression. Now, and one point that I want to make here is that coming from ancient Greece, from ancient Athens, there were two concepts of freedom of speech. One was a concept that we adopted, which is freedom of speech on any single subject you can think of. The other concept was freedom of speech on topics of public interest. That's what Europe adopted, the European countries. So for example, when the Phelps announced that they were going to go to England to picket at the funerals of English soldiers, they landed Heathrow, and the authorities at Heathrow look at their passports and say, oh, you're the Phelps. No, you go back home. We're not going to allow you to enter the United Kingdom. Why is that? Because of what you're going to say. In Germany, you go to jail if you deny the Holocaust. If you say the Holocaust didn't occur, there's a German law that will put you behind bars. Every single one of the European countries that have freedom of expression adopted this concept of freedom of expression. The Europeans think we are out of our minds to allow things like hate speech. to allow denial of the Holocaust. And how many times, I mean, if you really spend a lot of time on social media, would you see things like the Holocaust didn't occur? Thousands of times a day. Why do we allow that to happen? Why do we adopt this theory of expression? I have a good friend, college friend, named Rod Smolin, who is a First Amendment scholar. He's been a law professor at 8 different law schools. And he's written a bunch of books on the First Amendment, and his idea is this concept of catharsis. Imagine, a pot, boiling water, you put the lid on. At some point, boom, lid blows off. Rod says that's what would happen in the United States if we had this European concept of freedom of expression. His idea is our First Amendment simply takes the lid off and allows people to say what they want to say, so you don't get to the point where people are prevented from saying what they want to say, and they turn to violence. That's why that's why January 6th was literally unique in American history, isn't it?
Then why hasn't that happened in Europe?
Because the Europeans simply, well, first, because the European countries are much smaller than the United States, their populations, and their populations are much more, what's the right way to put it? Homogeneous. Homogeneous.
Civilized?
It's a matter of opinion, but you go to France, the vast majority of the French are Catholic. You go to Germany, vast majority of the people, other than in Bavaria, are Protestant. The Bavarians are Catholic. So you don't have sort of a geographical situation where you have people of all different religions and all different backgrounds kind of living in the same place. This is just kind of my spitball on the topic. And they, and then on top of that, they have the tradition of monarchy. The United States never had that tradition. Never, from the start, we were not a monarchy. Look at the Napoleonic Wars. Why did they happen? French Revolution takes place in the late 1780s, early 1790s. They overthrow the king, Louis and Marie, and they off with their heads. Scared the bejesus, the hell out of the rest of the European countries, who were all monarchies. They got together as an alliance. The English, the Austro-Hungarians, and the Russians got together and invaded, attacked France. That basically was what the Napoleonic Wars, lasting in 1815, was all about. The European countries afraid that this virus of republicanism would infect the rest of Europe. Eventually it did. So it's just the idea of, why can't the Phelps go to England? It's because they have a different concept of freedom of speech. Freedom of the press. Writing, printing, whatever. And I just view it as, like I said, the flip side of, one side of the coin is freedom of speech, the other side of the coin is freedom of the press, freedom to express yourself in writing. And I always already talked about this sort of idea. How am I doing on time?
Well, you're doing great.
Am I?
But we do want to save some time
I know.
for questions from the audience.
Oh,
So
absolutely.
it's fascinating.
Okay, so freedom of assembly. This is something that a lot of people kind of forget. Imagine groups like the NAACP, the ACLU, League of Women Voters, Women for Kansas. What is it? It's nothing more than a group of people getting together because they kind of think the same way. They have the same opinions about things, and they want to advocate for that. It also protects things like labor unions. You see a strike, and there are people out there with picket signs. They are exercising the right of assembly, the right of association. I always surprise people. In my career, I've done a good deal of labor and employment work. It's like, me going up and talking to the Phelps and saying, okay, let me look at your signs, and I take pictures of them. I do the same thing with union picketers. I'll walk up to them and say, so what do you want to strike about, or what are you protesting about? They're always surprised when nobody wants to talk to them. And I take pictures of their signs. They are literally a walking example of the right of association, the right of free assembly. Sort of the biggest example of that is political parties. Now think of the kinds of things that political parties do. Obviously, nominate candidates, advocate for their election, but they also raise money, they spend money. Where does the money come from? From people who support their candidates. So you can see that the right of assembly is something that at first blush doesn't seem like a big deal. It really is. You want to have a parade down on Mass Street, you're exercising your right of assembly. You want to have an event take place at the gazebo in South Park, same thing. All of these are part of the right guaranteed to you by freedom of assembly. And then finally, right of petition. Now, this is something that we personally exercise quite a lot. But there are some people who really do go directly, personally, to City Hall to protest about things. This guarantees your right to testify at legislative or city council hearings about an issue that's of concern to you. It's a right that has been used to render unconstitutional attempts by the government to limit your ability to express yourself. It's nearly every state has a law that this is what happens. Somebody wants to testify about an issue, and other parties or the government try to prevent them from testifying. And how do they do that? How do the private parties do that? They file lawsuits against them. They'll file a libel lawsuit saying that this person testified about things that aren't true. Well, as a consequence of that, nearly every state has a law that says that those types of lawsuits are not allowed because they are intended to prevent people from exercising their right of petition. This stuff gets really complicated. I don't want to get way down in the weeds on it. But I do want to introduce to you a concept that's something that we're dealing with. We dealt with right at the start in the 1790s, and we're dealing with today, and that's the concept of sedition. It sounds terrible. Sedition has kind of a bad connotation. The dictionary definition is it's nothing more than criticizing the government or criticizing an office holder. And that's perfectly fine. That's protected by our right of free expression and our right of petition. But at some point, seditious speech can become unlawful. January the 6th is a perfect example of that. You had all these people who organized the protest, who led the protest, many of them who were convicted of something called seditious conspiracy. There's a federal law that says that you cannot conspire to overthrow the government by use of violence. What were they doing on January 6th? And of course, Oath Keepers, and 3%ers, and the Proud Boys and the like, a number of them were convicted of seditious conspiracy, sentenced to long prison terms, and they are now out good part. But sedition. Okay. I want to tell you a little bit about what I call the constitutional hierarchy, because you'll hear about, lawsuit filed to have a law declared unconstitutional. The pecking order is this. If you have a law or a regulation or a municipal ordinance, and each of these address the same issue, but they're inconsistent with each other. If there's a lawsuit, which one wins out? If it's something in the Constitution, that beats everything else. So if you have a state law, a state statute, that says that we will not allow any parades on Mass Street, but you have a First Amendment that says freedom of expression, which wins out? Because they address the same topic, but the results are inconsistent with each other. It's the Constitution that wins, and the state law is declared unconstitutional and can't be enforced. So when you hear about some law or some municipal ordinance or a regulation being declared unconstitutional, just keep in mind that happened because there was something higher up on the hierarchy that trumped it. Yeah, I know. Okay. So, here are some specific rights that you have, or rights that perhaps you think you might have that you really don't. And I'll just kind of go through them as kind of individual topics. Copyright and trademark. Copyright, trademarks, patents. You bought a book. The book is copyrighted. What does that mean? It means you cannot, except for a few specific exceptions, you cannot copy that book. That is actually in the original Constitution, not even in the amendments. But copyright and trademark and patents are really nothing more than limitations on our First Amendment rights. Limitations that have been found to be lawful, found to be constitutional. So when we talk about our rights under the First Amendment, keep in mind that there really are restrictions that are not just appropriate, but they've been legally found to be valid. Do students have free speech? Well, the Supreme Court has said yes in I have a picture of the, okay, in a case involving these two folks. This is John and Mary Beth Tinker, who were remarkably 10th and 8th graders at the time in Des Moines, who protested the Vietnam War in 1965. These are the armbands that they wore. I was on a panel with Mary Beth 6-7 years ago. She became a nurse and a really nice lady. And in the Supreme Court case, the school district suspended them for doing it. And their case made its way all up to the Supreme Court. And the Supreme Court in 1969 said that students do indeed have free speech rights. But since 1969, the court has been cutting back on that. And that's what this quote says. There are restrictions on it. Public schools can censor student newspapers, for example. That's the Hazelwood case from 1988. But a few states responded to that by passing laws that say that schools may regulate the number of copies printed, whether it's in color or black and white, whether it's a broadsheet or a tabloid or the like, but they can't regulate the content. Students are allowed, high school students, are allowed to write what they want to write about. So if you talk about the budget over at Lawrence High School, I don't know what they call the student newspaper at Free State, But those students, with respect to content, are not constrained by any state law. Now, they can't go to the principal and say, we want to print 10,000 copies this week. The principal would say, there are only 900 students. No, we're only going to print 500. Now, the school can regulate that. But with the exception of the states that have adopted laws like this, and it's a handful, good-sized handful, not a lot, Kansas most importantly. With the exception of that, schools can even regulate content. They can engage in censorship. Okay, let me go back. So student free speech, you have the right not to speak. A cop comes up to you and asks you a question, you have the right not to answer the question, just to stand there and say nothing. Will you do that? I don't know. I mean, there's a difference between what you can do and what you should do. I tell my students, if a cop asks you a question, answer the question. You know, because he or she is not going to be happy if you just stand there mute. But the right not to speak includes things like being forced to engage in prayer in school. Every high school football game you go to, there's going to be a benediction. And usually they ask you to stand for the benediction. You don't have to. You're doing nothing wrong by sitting and thereby saying, I'm not participating in this because I have the right not to participate. So always remember that the right to speak carries with it sort of the countervailing right not to speak. And here's a concept that marketplace of ideas. This was provided to us by the famous Oliver Wendell Holmes Jr. when he was a member of the Supreme Court from 1902 to 1932. Wrote a famous case in which he came up with this idea of the marketplace of ideas. And that is sort of part and parcel of how we deal with things economically. There are good products and there are bad products, and which one wins out? We like the good products. Those are the ones we're going to buy. The ones we're not going to buy eventually will go away. And he applied the same idea, the same concept to ideas. He said, let everybody say what they want to say. I mean, to me, I don't care, in my voting rights cases, I say, Judge, I don't care if people want to vote Republican, Democrat, Communist, Socialist, Anarchist. I don't care. Just let them vote. And Holmes kind of said the same idea. Let people throw things out. A lot of the spaghetti is not going to stick to the wall. And why is that? Because people read it and they say, well, that's ridiculous. I'm not going to ascribe to that. On the other hand, he says maybe there's some novel idea that is not accepted today, but as our society evolves, maybe 10, 20, 30 years from now, it'll be viewed as reasonable and something that, yes, we believe in. His point is that the government shouldn't pick winners in terms of ideas or thoughts. It's the people who pick winners. Limitations on the criticism of government. Sedition, you can really only go so far. You can go a long, long way in criticizing the government. But at some point, the government has the power to say you can't go any further. And today, that's when you start advocating for the overthrow of the government using violence. That is unlawful sedition. Short of that, you can say, let's overthrow the government. Or how are we going to do it? At the next election. Perfectly fine. Nonviolent replacement of the government. That's something that we would like to think we do all the time. I don't like the guys we just elected. Let's wait 4 years and throw them out. Use the ballot box to do it. Nonviolent methods. But the government is within its powers to say that the method of overthrowing the government can only go so far. Can't use violence. That's why what happened on January the 6th was properly subject to prosecution for unlawful sedition, or we call it seditious conspiracy. Threats. How far can you go in threatening somebody? There have actually been 2 pretty important Supreme Court cases on this concept in the last 5 years. How far can you go in sort of threatening people on the internet? You can go pretty darn far. It's only when you start, again, threatening violence that the government can step in and say, you can't say that. If you continue saying that, we're gonna throw you in jail. But short of that, you would be surprised how far you can go. I mean, think about all the stuff we're hearing about FBI agents saying that they're being threatened, members of Congress saying they're being threatened, and they are. But you have to actually read what the threats consist of to determine whether it's within the rights of the people to say those things, or whether they have stepped over the line. So just keep that in mind, that you don't have an unlimited right to threaten people. Prior restraints. Prior restraints are government action to prevent something from being published, to prevent something from being said. The classic example of that, keep the age of the people here, you'll remember, just like I do, the Pentagon Papers. In 1971, a study of how we got stuck in Vietnam it was a secret study. It was leaked to the New York Times and the Washington Post, and they started publishing articles. The government, for the first time in American history, the federal government tried to stop the publication of anything. In this case, they tried to stop the Post and the Times from publishing stories that in essence were embarrassing. You go back to the post-World War II era and come forward, and you read all this stuff, and it was secret, it was cables and diplomatic communications and the like, and you read it and you go, is this what happened? Is this how we got stuck in Vietnam? These decisions were harebrained. Had we known what was going on, perhaps we would have said, no, 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 we're not gonna do this. But what the Supreme Court said, that's what the government was trying to do. It was trying to prevent that type of information from being made public. We call that a prior restraint. And the Supreme Court said, any prior restraint comes to us with a nearly insurmountable burden to overcome. Prior restraints, to say they're disfavored, is an understatement. There are only a couple of situations in which they're allowed. One is national security. Do you think it would be appropriate for someone to publish the detailed specifications of our next generation of jet fighters? Probably not a good idea. And the government would try to stop that, and the courts have said that's entirely appropriate. If it's a national security issue where people's lives would be in danger, we can stop that. Pentagon Papers was different. Maybe you'd say it's national security, but nobody was going to get killed as a result of it. The United States was humiliated as a result, but the court said so. And the other situation is where it might jeopardize somebody's right to a fair trial. There's been a hearing about whether a confession should be admitted at the defendant's trial, and the defendant says they beat the confession out of him. And I think we all agree that confessions obtained under duress should not be used, but there has to be a hearing for the judge to decide, okay, what happened? Are we going to allow this, or are we not going to allow this? Well, if the newspapers published a story about that, perhaps the folks who eventually become members of the jury say, when they're being questioned, they say, well, you know, I read this guy confessed. I read a newspaper story that said he confessed. Well, you didn't read the whole story, in which the judge said the confession would not be admitted into evidence. And so that's the other type of situation. And that's one where you have two constitutional rights fighting each other. First Amendment, Sixth Amendment, right to a fair trial. And then, finally, do I have any others? No, that's it. This is one. You can voluntarily give up your rights. You can sign something that I give up my right. A good example is if you want a job at the CIA. Today, you know, you go in and you fill out all these papers, your tax deductions and your withholding and insurance and all that. There will be a document there that says that if you choose to write anything about your experience at the CIA, you must submit it for pre-publication review to make sure that no secrets are being disclosed. That is a voluntary waiver of your First Amendment rights, and that is perfectly appropriate, as the courts have said. Okay, I think I've covered all this stuff.
Okay.
Okay?
Let's just take a moment to thank Mark Johnson for this fascinating. This was a condensed version, perhaps, of a semester-long class.
The Reader's Digest condensed version or something.
Thank you all for your patience in listening. We are going to open it up to some questions. We do know that some people may need to leave. We do have the materials in the back of the room from the ACLU. We have the bumper stickers for yourself. Don't forget that. But does anyone have a question for Professor Johnson?
Real quick, as you go through all of this, I feel like our rights are being trampled on currently. So what two things could you tell ordinary, this is my opinion,
Sure.
and I'm calling myself an ordinary person. What can I do?
You're not, well, first, you're not an ordinary
Okay.
person,
I'm a
simply because you're
citizen.
asking the question. But that's what it says in the part. What can you do? Well, the default is you can say what you want to say. Much of the time, when we talk about the First Amendment, we're talking about exceptions. 99+% of what you want to say, you have the perfect right to say.
But I don't have a big voice, so how do I, going to the Capitol and standing out in front, does that make any difference to those Republicans at that State House? What is it that maybe I can do?
Well, the first and obvious one is voting.
Yeah.
Voting for candidates that think as you do. But I understand the reality of living in Kansas. But there are some places, Lawrence, I mean, here's one way you can do it, is make sure, to the extent you can, that everybody elected from Lawrence or from Douglas County thinks the way you do. Now, a lot of that depends on how the district lines are drawn. So that, I mean, that's one thing, and it's kind of slow. It's a slow process. The other is just talk. I mean, I heard the yard signs mentioned. It's been empirically proved, and I do a lot of election work, it's been empirically proved that the candidate who has more yard signs gets like a 1 to 2% bump in votes. Why is that? Because other than who your parents are and what their political persuasion was, the next best predictor of someone's politics is their neighbors, their friends. And so if you're driving down the street in your neighborhood and you see a couple of yard signs for, and it usually works for candidates who aren't terribly well known or running for sort of down ballot offices. What that does is, if that person driving that car might be inclined to vote in a certain way, seeing those signs validate that person's opinion. So don't be reluctant. I mean, some people don't like going door to door and doing it personally, face to face. A yard sign is a remarkably effective political tool that we've all lost. Another thing you can do, that's not easy in Kansas, is working a poll. And of course in Kansas you have to be at least 250 feet from the entrance to the polling place. This is something I want to talk to you about. You work the poll in your area, and inevitably you'll see some people that you know as they're going to the poll. And if you ask them to vote for a certain candidate, if they don't have any opinion on the race before they go in, they're more inclined to vote for them. Let me ask you this. One of the cases I had a few years ago was a challenge to this 250-foot boundary beyond which election activity is not allowed. And we lost because the people that we used didn't have standing. What I want to do is basically create a test case with people who do have standing, and I can sort of figure out the ways to do it, so we can present the case to a federal court here in Kansas. 250 feet, think about that. I mean, I live in Missouri. In Missouri, it's only 25 feet. But 250 feet here, that's almost the length of a football field that you can get no closer to the polling place. And so people going in to vote, you really don't have a right to, you can't influence them because, you yell at them and they're not gonna hear you. So if there's a municipal election coming up in Lawrence, I want to create a case. So, test cases are absolutely fine. Don't think that this is somehow something that's wrong. But I want to be able to create a case that has the right kind of facts with plaintiffs who have standing. That's a technical issue. So a federal judge has to look at this law and say, this is a violation of the First Amendment because these people are not being allowed to express themselves, express their support for particular candidates. So if anybody's interested, put your name on that. Anyhow.
Was there another question?
Yeah, I'll tell you, to answer your question is it's really tough. It's really tough. You just have to have the courage of your convictions, talk to your neighbors, talk to your office holders. Yes, ma'am.
So is it okay for Trump to have people sign NDAs in his administration, or I guess they would have the, right not to sign it, you wouldn't hire them. But is that?
Ultimately, no, because the information that he's trying to protect all information. The kinds of documents I was talking about was trying to protect national security information. I think his NDAs are way too broad. I don't think they're enforceable. But the thing is, if you don't sign it, you don't get the job. And so whoever does that has to have the courage to go to court and say, he is asking me to give up my First Amendment rights in return for getting a job. And you can't do that.
One other thing, is there a way to follow your pro bono work?
Well, I suppose if you want to, maybe I could put a list together of folks I sort of send blast emails to about what kind of stuff I'm doing.
If people want to contact you, do you want to share an email or? is that-
It was
It was on the
Oh,
first slide.
okay. Did everybody get that?
Request the slide.
Yes.
Oh, yeah.
Could you repeat the question so we can't hear
He's not
them?
being constrained by law. Here's the error. She's talking about the executive orders.
Uh-huh.
A number of, and I don't know how many he's done, but the ones I've taken a look at are almost all in one way or another unlawful.
Then why is he permitted to carry them, to act upon them?
Because it takes time to present these situations in the courts. And he doesn't care about that. I mean, he's operating under the assumption that only so many of them can be challenged. You know, people will only have high resources to challenge only so many.
And there are lawsuits now.
Oh, lots.
But what if he just says, I'm not, I don't care, if the court
There's,
says,
okay, there's a real problem.
yeah.
The court has to be able to stop him
If they don't
at
have it,
some
they don't have
point.
it.
Yeah, I mean, there's a famous quote from like Andrew Jackson. He said something like, well, you have your judgment, now enforce it. And that's the nightmare scenario, is if the courts tell him to do something, he simply ignores it.
Which is what he's doing.
That actually has been stopped.
What's
That's
the
been
stop, but
enjoyed.
the funds aren't going, so.
I can't.
I don't know the details of that stuff.
The funds, the payments to, right, the judges have said, no, you can't keep doing that, we have an injunction, but there's still not the funds that are being used up.
Well, I mean, the difficulty is that the judicial process requires that there be a determination that he's actually not complying with the court orders, and then he can be held in contempt and. But the nightmare scenario is if that he simply doesn't, I guess if there's a super nightmare scenario, is where the people working for him in the executive branch, they also refuse to enforce the orders. I mean, I think that if we get to that, or we approach that, there are going to be a lot of people in the Army, the U.S. Marshal Service, and the like, who will simply say that is an unlawful order and we're going to follow it. Yeah. Yeah.
There's a question on this side.
Yes, ma'am.
Okay, my sons, when they were in the military, they were granted high security clearances. My sister, when she worked for the federal government, was granted a high security clearance. So how can people that are not granted any kind of security clearances be able to go in and access my social security information, for example?
Well, easy for me to say they can't, even they're doing it, they can't do it. And so what has to happen, and I think is starting to happen, is that those actions are being challenged in court. I mean, what's his name? You know, Musk's thing about the USAID was just enjoined yesterday, laying off the employees of the AID. That was put to a stop yesterday. And these other people, you know, who don't have security clearances accessing that information, they are committing crimes. And what has to happen?
But they won't
is
see
some-
jail.
Well, there's a difference. You've got federal prosecutors and state prosecutors. Trump can't control the state prosecutors, one. And two, there will be federal prosecutors who refuse to follow his orders. There's already the acting director of the FBI is saying, no. And there will be a few people, maybe growing numbers, as if he continues with this campaign, who will say, no, we're not going to follow the president's order on this because we view that order as being unlawful. Some of them will lose their jobs. It's going to be very difficult. The thing,
What should we be doing to protect our information or ourselves at this point? Do you have?
oh
any
gosh,
suggestions?
I'm not a privacy expert. Well, number one, don't give your information to anybody. That's, just don't. I mean, they ask you for your social security number, you say, no, I'm not gonna give it to you. What's your address? Address is probably okay. But social security number, any kind of government number, you get, just don't give it to anybody. That will stop it, but I mean, for the people who have it already,
They've already got it.
Yeah, I was gonna say medical insurance, a lot of
They
people
got
have.
everything.
Yeah.
well, there are federal laws, the Federal Privacy Act, that make unlawful the distribution of that information.
Yeah.
Most
but then you
companies
have-
are
But,
pretty.
but we currently have, high school graduates forcing their way in and taking it
That's-
anyway.
Yes, and the fact that we know about that now is resulting in challenges to that. I mean, one of those kids,
It should not have been,
there's a long story in the
Possible.
Washington Post about it yesterday.
We have one more question here, and then we're gonna need to wrap.
Go ahead.
What time
Go
is
ahead.
Just a quick question, I hate to bring it back to the First Amendment here, but a lot of us on campus are in quite a quandary. Ever since guns on campus were approved, quite a number of faculty and some staff and GTAs have been threatened. And when the complaints went up to General Counsel's office, they said, oh, First Amendment protects them. Is there a good document or a primer that faculty and GTAs in particular can look
Yes,
and say,
put
okay,
your name down on the list, I'll send, if anybody wants it, I'll send it to you.
thank you.
It was something put out by AAUW, what's the AAUP? Right, American, why you laugh?
The reason I laugh is that my husband's the head of the AAU.
Oh, my gosh.
Locally.
We need
And
something more
he needs more
authoritative.
help.
Okay, I'll see what I can do about that.
Okay, I'm gonna wrap it up because I know people need to leave.
I gotta get home to watch the Jayhawks, come on.
Yeah. But listen, in the back, there are little cards, know your rights, for immigrant rights, but also for all of us, if you're stopped by police or in your car. Reimagine justice, a Kansas lobbying tool. You hear the cry right now, call your representatives. The phone lines have been jammed all week in the Congress, but we
That
need,
is true.
we
It
need
is
to
true. Yes, it
People are
is.
finally figuring it out.
we need to continue. There's several apps you can get, the 5 Calls app, but continue to call and contact senators, representatives, state level as well. People in the LGBT